Swayam Prabha. Digital India. Educated India.
Hello all, welcome to this module on European competition policy and intellectual property rights. In this module, we are going to briefly discuss about the European competition policy, the main provisions under this European competition policy which we can relate to the various aspects of intellectual property rights and their commercialization in the market. Particularly, we will be dealing with the Article 101 and Article 102 of the Treaty of Functioning of the European Union. There we will discuss the various scopes and application of those articles, and finally we would like to discuss little bit about the competition policy and intellectual property rights, which will be discussed in a greater length in the next modules. The competition policy in the European Union is a vital part of this internal market. Basically, the European competition policy aims at providing a healthy and fair competition among the players in the market, otherwise the companies which are offering different goods and services in the market, so that the people of the European Union can get a better product and services at a reasonable price. Also, there are set of rules and regulation within this European competition policy which regulates the European market, thereby providing a better quality material to the material or substances to the consumer, as well as it offers more choices to the consumer. And if you totally look into the basic objectives of the European competition policy, so the major objectives are as follows. For example, one of the major objective is to provide goods and services at a lower price. As you know, to gain any market, one of the easiest or important thing the market operators or the companies think is to provide the goods and services at a better price or better quality of the product. So, reducing the price of these substances along with maintaining the quality is an important aspect. So, the EU competition policy ensures this. Also, they also ensure the companies operating within this European market provide better quality product, and since there is a fair and healthy competition, the companies would definitely try to come out with more different kinds of the product which are different from the existing product. So, the consumer would get more choice for their product, and this in this process of making different product, there comes the part of the innovation. So, the European competition policy further ensures innovation, and all this together not only leads a good competition in the internal market of the European Union, but also it also leads to a better competition in the global market. And all these are achieved with set of rules and regulation. So, basically the European Union's antitrust policy arises from the two central rules which are set out in the Treaty on the Functioning of the European Union, and these are the Article 101 and Article 102. So, in this module we will discuss these articles one by one, and first we will discuss in context with the competition policy, then in the later part of this section we would try to correlate these sections along with the aspects of the intellectual property rights. So, the Article 101 basically prohibits agreements between two or more independent market operators which restricts the competition, and these provisions covers both the horizontal agreement as well as the vertical agreements. So, what are those horizontal agreements? Basically, horizontal agreements are the agreements between the actual or the potential competitors operating at the same level of the supply chain. Means if there are two manufacturers which are manufacturing two similar kind of products, so they are said to so we can say that they are operating at the same level of the supply chain. And vertical agreements are those agreements between the firms or the companies where the companies are at a different level of the supply chain. For example, the agreement between a manufacturer and its distributor. So, basically article 101 prohibits agreements between these kind of firms or the companies which may restrict the competition in the market. There are few exceptions are provided under this article. However, the one of the prominent example for the article 101 is the prohibition of the creation of the cartels between the competitors. Basically the cartels are the we can say the cartels are the group of the companies or operating at the same or different levels, so that they may involve in price fixing or market sharing. So, if we look into the article 101, actually there are 4 important things which needs to be taken into the consideration. For example, there are certain like the article 101 directly states like it prohibits the agreements between the company so that which inhibits the competition in the market, but there are certain exemptions provided under this article 101 under subsection 3. And it talks about the undertakings and association of the undertakings, means under by the agreements between agreements between the companies between which the agreements are taking place, like what is the status of this company, like whether what kind of company can be liable for this violation of the competition rule. So the concept of undertakings and association of the undertaking is also very important to understand the concepts. And there is another thing, the de minimis doctrine, so which we will discuss a little bit, and the object or the effect of restricting or distorting the competition. So, there are 4 important aspects of this article 101 which is very important, and we will discuss this one by one. So, article 101 prohibits agreements which are directly or indirectly fix purchase or selling prices or any other trading conditions. Second, they limit or control the production, market, technical development or investment, or any agreement which share markets or source of supply, and it prohibits agreements which apply dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage place. And the agreement which makes the conclusion of the contract subject to the acceptance by the other parties of the supplementary obligations, which by their nature or according to the commercial uses have no connection with the subject of such contracts. So, these are the few things which has been stated directly under this article 101. However, article 1 subsection 2 of this article 101 also says that any agreements or decisions prohibited pursuant to this article shall be automatically void. So, any agreement or any decisions which is directly mentioned under this article subsection 1 of this article 101 will stand automatically void. However, these subsection 2 of this treaty is silent about the concentrated practices and only talks about the agreements. So, as you know, the agreements and decisions may create rights and obligation, whereas the concerted practice does not create any rights and obligation. So, here it is remaining silent about these things. And under section under subsection 3 of article 101, there are certain provisions are given where the provisions of the paragraph 1 may stand inapplicable. For example, in case of any agreements or category of the agreements between the undertakings or any decisions or concentrated practices between the undertakings which contributes to the improving the production or distribution of or promotion of technical or economic progress. So, if any of this agreement is leading to the production or distribution of the like improvement in the production or distribution of the goods, or promotion of the technical or economic progress, then it won't be considered as a violation for this won't be considered as a violation of this competition policy. And because as you know, the European competition policy basically aims at promoting a fair and healthy competition in the market, which promotes consumer welfare and also enhances innovation. So, consumer welfare and promotion of the innovation or promoting more technical advancement is the basic objective of the European policy. So, whenever there is an agreement, these the agreements are always looked into two dimensions, whether they are promoting the innovation or whether they are promoting more more competition or not. So, basically these things are looked into, and then it is decided whether the agreements are anti-competitive or pro-competitive in nature. So, final, the balancing of this anti-competitive and pro-competitive effect is conducted within the framework like laid down in the subsection 3 of this article 101. And basically, as I mentioned earlier, 4 conditions are taken into consideration. First, if there is any gain in the efficiency of the process, if the consumers are getting any fair share or any benefit at the end of this agreement, or those all those restrictions which are placed in the agreement are really indispensable to the whole process, or was there a better way of achieving all these things, and is there elimination of competition or not. So, basically these 4 aspects are looked into, and accordingly the decisions are made whether the agreements are anti-competitive or pro-competitive in nature. So, again, so while judging the anti-competitive agreements, so we all the court has looked into during this various case laws, the court has evolved with this de minimis doctrine, which basically states that the negative effect of the agreement on the competition is so small that they have no appreciable impact either on the competition within the purview of the article 101 subsection 1 in the market, nor in the interstate trade. Means all of this process might have a positive and the negative aspect. So, they are weighed like the pros and cons are weighed with each other. So, if the negative effect of the agreement is very small, or they do not have any substantial effect on this competition within the market, then like it will not be considered as a anti-competitive practice. So, this doctrine was first formulated by the Court of Justice in the case of Volk versus Bourbaki. It is a quite old case, like in 1969 this first judgment came, and there they have come out with this doctrine. Now, one of the other important aspect of this European competition policy is article 102. So, basically article 102 prohibits the firms that holds a dominant position on a given market to abuse that position. So, basically it talks about the abuse of dominant position. So, one firm or a company can abuse the dominant position either by charging unfair prices, or by limiting the production, or by refusing to innovate, which is basically a prejudice to the consumers. So, both article 102 and article 101 are important parts of the Treaty of the Functioning of European Union. So, basically article 101 deals with the agreements, decisions and concentrated practices which are harmful to the competition, and article 102 is directed towards the unilateral conduct of the dominant firms which act in a abusive manner. Basically article 102 prohibits certain forms of the unilateral market behavior. So, article 102, the text says that any abuse by one or more undertakings of a dominant position within the common market or in a substantial part of it shall be prohibited as incompatible with the common market in so far as it may affect the trade between the member state. So, the abuse may in particular consist of directly or indirectly imposing unfair purchase or selling prices or other unfair trading conditions, by limiting production, markets or technical development to the prejudice of the consumers, applying dissimilar conditions to the equivalent transactions with other trading parties, thereby placing them into a competitive disadvantage, making the conclusion of the contract subject to acceptance by the other parties of the supplementary obligations which by their nature or according to the commercial uses have no connection with the subject of such contracts. So, these are as per the standard text of this article. So, basically if you look into the major elements of this article 102, so it we can come out with this, it applies only to the undertakings, and these undertakings must hold a dominant market position, and the undertaking must abuse their dominant market position in the relevant internal market or substantial part of it. And basically these abusive practices can be of various types, for example, exclusionary abuse, exploitative abuse and discriminatory abuse. And the abuse of the dominance affect trade between the member states. So, these are the important point which comes out of this article 102. So, the article 102 expressively says that the provision is not only applicable applies to the abuse of the dominant position by one firm, but it is also applicable in cases of a collective undertakings where two or more undertakings come together and hold the dominant position. So, this article does not say that dominant position is bad or dominant position per se is prohibited, but it is only the abuse of dominant position which is prohibited, and this abuse of dominant position is determined when there is a appreciable adverse effect on the competition in the market, and this is prohibited under the 102. There are certain criteria by which the court or the commission decides whether these practices are creating appreciable adverse effect on the market or not. Based on their investigation, they come out with their own observations, and accordingly it was decided whether there is a abuse of dominant position or not. So, the decision of the European Commission may be challenged at the court, like at the General Court or European Court of Justice. So, these are the two important provisions of the European competition policy. So, as we are discussing the article 102, so the dominant position, again there is a question like what can be considered as a dominant position. So, a dominant position can be defined as a position of the economic strength enjoyed by an undertaking which enables it to prevent effective competition being maintained on the relevant market by giving it the power to behave to an appreciable extent independently. Means if a company is enjoying a reputation in the market by which it can affect the competition by exercising one of its monopoly power or exercising any of this activity. So, it may be considered under the considered to have a dominant position, and again dominant position per se is not prohibited. If the company abuses its dominant position, then only it comes under the provisions of the article 102. And again the abuse of the dominant position is always looked into the relevant market. So, the relevant product market comprises all the product, all the services which are regarded as the interchangeable or substitutable by the consumer. So, if there is one service, so while considering the relevant market, we may look into whether this kind of services can be replaced by any other services or not. So, they consider it like all the interchangeable or substitutable substances by the consumer, and by reason of the product's characteristics and their price and the intended use. So, these three factors are also taken into considerations, and supply side substitutability may also be taken into account while defining the market. Like if the product is not manufactured in one place, can a supply chain fill the void or not. So, all these things are considered while considering the relevant market, and the behavior of a dominant player is judged in the relevant market and whether it is abuse of its position or not, and then the decision is always taken. So, these Article 101 and Article 102 basically tells us or gives a fair idea about what kind of agreement or what kind of behavior of a firm or a company is or will be considered as anti-competitive. So, with this background information, now let's discuss about a little bit about the interface between the competition law and intellectual property law. So, basically as we know, intellectual property rights are a kind of monopoly right which is given to the inventor for his or her innovative creations. It may be in the form of a patent, a trademark, a registered design or unregistered design, then again know-how, trade secret, all these are essential part of this intellectual property rights. And since it is a kind of monopoly right, so when we talk about the monopolistic right, means we have the monopoly or the inventor have the monopoly over the right. So, it is a kind of exclusionary right. So, we exclude or the inventor excludes the other from using that right. So, in a strict sense or in a at the first instant it seems to be a kind of anti-competitive, means from the very beginning we are removing any kind of competition. But if you look into the more deeper aspect of the intellectual property and also into the competition policy, even though at first it sounds like these are completely two different form of laws, but again they share the common goal or objective. Basically creation of or promotion of the innovation and consumer welfare. So, consumer welfare and technical promotion of the promotion of innovation are the two major aims of both competition law and IP law. So, in this respect both of these laws are quite synergistic or go side by side. However, while judging the various overlapping dimensions of the competition law and intellectual property law, it is generally looked into two directions. Like we always the aim of this competition policy is to increase the market efficiency. So, there are two kinds of like the theoretical scientists basically has come up with two kinds of efficiency. One is known as the static efficiency and other one is the dynamic efficiency. So, static efficiency is basically the how the product is being marketed, or when we decrease the price of a product, when there is more competition, the price of this product it increase, the more there is more marketability of the product. So, that kind of thing comes under the static efficiency. And dynamic efficiency is basically the promotion of the innovation or more technical know-how, so that more more player comes to the market and new products come to the market, which directly or indirectly promotes consumer welfare. So, when we deal about the questions of intellectual property right and competition law, so the practices associated or the conduct based on the IPR are calculated or analyzed in terms of both static efficiency and dynamic efficiency. When both the static and dynamic efficiency the sum total of these two are positive, then it is not anti-competitive. But when the static efficiency and dynamic efficiency sum total is negative, then the conduct of this IPR is considered to be contrary to Article 101 and 102, and the firm or the company may be considered as an anti-competitive in nature. The guideline on the technology transfer of Article 101 and Article 102 also, they have mentioned about this theory of complementarity. Means they say that the competition law and the intellectual property shares the same objective, means the promoting consumer welfare and efficient allocation of the resources. So, by virtue of this, the intellectual property is or the company operating with the help of this intellectual property are not immune from the competition law aspect, and both the competition law and intellectual property law go side by side. So, with this this is a brief introduction to this IPR and EU competition policy. In the next modules, we will discuss about the licensing agreements under Article 101 and various agreements under Article 102 with respect to intellectual property rights, and how they how it is decided whether some agreements or some arrangements are contrary to this Article 101 and Article 102 and considered to be anti-competitive in nature. So, with this we will stop here and we will start with the next module. Thank you.